Army, this Marine Corps, this Air Force, this Navy, this Coast Guard, Reserves, National Guard, and you veterans. And these police officers. Now Dave is going to read these in summary, and then we'll elaborate a little bit on each point.
We will not obey orders to disarm the American people.
And as you well know, the attempt to do just that on April 19, 1775 led to the fighting and the revolution. We fear and we are concerned that the same thing could happen again and once again be the spark. And that's right, not on our watch. And that's the last thing we ever want to see, is to have our military men and our police used against us. As one young deputy sheriff from Texas said, he said, "I don't think David Rockefeller knows how to fly an F-15. or how to drive a tank. Or how to put on riot gear and thump heads with sticks. He doesn't know how to do those things." So he didn't say thump heads. He said use pepper spray. But he doesn't know how to do those things. He said they can't do it without us. They can't do it without you. Without you, they're powerless. That's our message and our mission. It's pretty simple, really. So one thing we do want to make clear, though, is these orders, we talk about these things, we're not talking about an officer who has to take a gun off a trunk before he puts them in the tank. We're talking about sweeping disarmament of the American people. Let's make that clear, okay? Dave?
Secondly, we will not obey orders to conduct warrantless searches of the American people.
But as I already said, that was one of the causes of the American Revolution, was the use of writs of assistance. And we have seen in modern days a very disturbing trend to say, oh, we don't need a warrant. We can just spy on you, whether it's the NSA or whether it's through national security letters or whatever other mechanism is used. Your security and your person, your papers and effects, and your speech, your privacy is in danger. And that's what we're talking about here. And in Katrina, we saw house-to-house searches without warrant, and we saw disarmament of people. And the two go together. How do you think they're going to do it if they want to take your guns away from you? They're going to go get a warrant for your house in particular with probable cause? No. It'll be by general sweeps through your homes or roadblocks and sweeps through your cars. So to protect the second, you better pay attention to the fourth. All right? All right.
Number 3. We will not obey orders to detain American citizens as unlawful enemy combatants. Or to subject them to military tribunal.
And this is something that's what I first saw when I was a student at Yale Law School that really kind of scared the hell out of me, frankly. I saw at that school both liberals and conservatives willing to treat American citizens as though they were over in Afghanistan or Iraq out of fear of terrorism. And the support of this claim that the president, once he's elected, is like an elected dictator. And that might sound like an exaggeration. But the claim is that the president, on his own say-so alone, can just designate anyone to be an unlawful enemy combatant and a combatant in the war on terrorism. Now the problem is that doesn't only apply to people from Afghanistan or Iraq. The claim is they can do it to you.
That's all of us.
All of you, that's right, all of you, any of you. And that power, that claimed power, was given a rubber stamp by the Supreme Court in 2004 in the Hamdi case, where the court said there's nothing that prevents the U.S. government from treating a U.S. citizen as an enemy combatant, which means that once the president designates you that way, there's no longer a requirement of indictment. You no longer get a jury trial. It could be a military tribunal that gets you. Just like the Star Chamber, the founders looked back on in the history of England and saw the Star Chamber, kangaroo courts. That's why you have a right to a jury trial in this country. So we are. That could also be a spark. Now, something you might not realize is that was first proposed back in 1995 by two lawyers who wrote an article in a law review. I believe it was Oklahoma City Law Review. They wanted to apply the laws of war to McVeigh and the militias back then. That's what they urged the Clinton administration to do, citing the same case precedents that were later used by the Bush administration to justify these things. So what Clinton did not have the power to do, Bush has put into place, and the Supreme Court has rubber-stamped it, and now President Obama could declare you an unlawful enemy combatant. Very serious stuff. Tyranny. That's right. There is no such thing as a constitutional republic where you can be black-bagged in the middle of the night. The two things are inconsistent. Every dictatorship in the history of mankind, whether it's fascist, communist, or whatever they called it, has always set aside the normal procedures of due process in times of emergency under claimed emergency conditions. In Nazi Germany, they were called people's courts. If you were a normal criminal, you go over to the normal criminal system. But if you were a political opponent of the state, they would take you to these special courts, handpicked by the Nazi Party, full of Nazis, and that's where you would be tried. What kind of a trial is that, right? Same thing happened in Stalinist Russia, kangaroo trials, show trials. We can't let that happen here. We need to wake up. All right.
Number 4. We will not obey orders to impose martial law or a state of emergency on any states.
Now, for each one of these points, when you go on our website, which is oath-keepers.blogspot.com, down the road we'll have a more functional website at oathkeepers.org. But when you go on there, you'll see the explanation in more detail of each one of these points. But on that one, what we're talking about here is that if there's going to be any emergency situation in a state, it needs to be handled by the state governor and the legislature of that state with that state's National Guard or that state's militia. Okay? When we get a revitalized militia, it'll be the militia. But for now, it darn well better be the National Guard of that state under the command of that governor. If he needs help from anybody else, he'll let them know, and he'll invite them. If he does not invite them, they've got no business in his state. Okay. Okay, good.
Number 5. We will not obey orders to invade and subjugate any state that asserts its sovereignty.
Now, we have seen lately a resurgence of an awareness of the 10th Amendment and of the importance of state sovereignty. This is a constitutional republic with a divided sovereignty between the national government and the states, as made very clear by our 10th Amendment. And we've had some people say, oh, well, you're trying to reconstitute the Confederacy. No, it's got nothing to do with the Confederacy. It has everything to do with the structure of the Constitutional Republic of 1787. And Jefferson and Madison, when they wrote the Kentucky and Virginia resolutions, that is what they were talking about. So we harken back to them. And all these resolutions, when you read them, they're basically just giving you a modern adaptation of what Madison and Jefferson wrote in those resolutions, pointing out the obvious limits and lines of the federal government's powers and the state's authority.